everyone. Welcome to the AI Policy Conference organized by ET at Zurich and RegHorizon. And welcome to the session on AI and the rule of law, which is co-organized with UNESCO. I am Prateek Sibal. I'm a program specialist at UNESCO's Communication and Information sector, where I work on AI and digital transformation. I would like to welcome you all to this exciting panel where we have speakers who are sitting judges, professors, and lawyers and researchers from around the world sharing their perspectives on the intersection between AI and legal principles. But before that, I would like to invite Mr. Cedric Wachholz, who is the Chief of Section for Digital Innovation and Transformation at UNESCO, to share his opening remarks and about what UNESCO actually does and why is UNESCO here. Over to you, Cedric.
Thank you, Prateek, for these kind words of introduction. Warm welcome to you all, your excellencies, ladies and gentlemen, dear colleagues and friends. Let me start by my intervention by quoting Alan Turing, considered by many as a father of artificial intelligence. He said, "We can only see a short distance ahead, but we can see plenty that there needs to be done." We need indeed to address AI and justice challenges, and many of us also want to harness related opportunities. My name is Cedric Wachholz. I am heading UNESCO's Digital Innovation and Transformation section in the Communication and Information sector, and I wish to thank the ETH Zurich and RegHorizon for this opportunity to contribute to the AI Policy Summit. AI and the rule of law is an area of increasing importance in our digital transformation work. Yes, upholding the rule of law and harnessing artificial intelligence for the judiciary is possible, but how can we seize the many new opportunities AI offers? Today, judicial systems around the world are increasingly using artificial intelligence to analyze large volume of legal data, identify judicial precedents, help administrators streamline court processes, and to assist judges with forecasts on topics such as sentence lengths and recidivism rates. These are just a few examples of how AI can impact the day-to-day work of judicial operators. But these examples lead also to important questions and challenges we have to raise in this context. How can we overcome AI bias to uphold the rule of law? How can AI risks towards the right to privacy be mitigated? How can AI potentially affect the right to equality? And how can judges support a human rights-based and ethical adoption of trustworthy AI? In UNESCO, we are committed to supporting judiciaries in defending human rights and the rule of law. Within the framework of UNESCO's Judges Initiative, UNESCO launched in March of 2022, together with the Future Society, the National Judicial College, CETIC.br, NIC.br, and IEEE, the world's first global MOOC, a massive open online course on AI and the rule of law. The course is part of UNESCO's Global Judges Initiative, which has trained over 24,000 judicial operators in some 150 countries on issues of freedom of expression, access to information, and safety of journalists, and now also on artificial intelligence. This legal training responds to needs expressed in a survey of judicial operators worldwide, to which more than 1,000 judicial operators responded. They spelled out what they wish to learn about the use of AI in judicial systems. And the course therefore addresses two main issues. First, something many of us dream of: how can judiciaries harness AI in their administrative work to strengthen access to justice and enhance administrative processes? And secondly, how can judiciaries address issues of bias and discrimination in the use of AI? And of course, the legal challenges these AI tools pose. Over 4,500 judicial operators from 140 countries have already engaged with our online MOOC on AI and the rule of law. In this context, UNESCO is developing a global toolkit for judicial operators on AI and the rule of law. And the toolkit will offer guidance on the principles, on regulations, and suggestions that underpin the responsible use of AI in judicial contexts. We trust this will be helpful, and we will assist judicial operators to reduce potential risks and assist enhancing judicial systems. I'm sure you're keen to learn more about this MOOC now. And before passing back to our moderator, Prateek, I kindly ask colleagues to play our MOOC teaser video. And I thank you already now for your attention and warmly invite you to participate in this course. Thank you.
Thank you, Cedric, for your remarks. And we would now be ready for an exciting panel. And first, I would like to introduce our moderator for the panel, who is Judge Isabela Ferrari, who is a federal judge, Second Regional Federal Court of Brazil, who has been a speaker in the MOOC as well, and a strong partner and supporter of UNESCO's work. Judge Ferrari, the floor is open for you to introduce the panel and take us forward in the discussion. Thank you.
Thank you so much, Prateek. I'd like to start saying that it's a pleasure to be here. It has been a pleasure to participate on this MOOC. And on our classes there, we were thinking about how AI would impact the legal field, and especially the judiciary. So the first thing that we need to understand to be able to discuss everything that we want to discuss today is the way that AI operates. So how does AI take decisions, and what are the advantages that arise from this resource, and what are the risks that we have? When we use AI to decide, we have the possibility of, instead of defining all the paths that will be taken in that decision, instead of doing that, stating everything that must be done, you give the system a lot of information, much more than we humans would be able to process. And the algorithmic system will find correlations in several layers among all of that information. And at the same time that it allows us to take decisions using an amount of data that we wouldn't be able to manage as humans. At the same time that using this resource allow us to take decisions that do not need to concentrate on each little step of this decisional path. At the same time that we do that, we must understand that AI decision making is probabilistic. So we're talking about probabilities. We can say that an AI system has, for example, 97% of accuracy, 98% of accuracy, what seems to be wonderful for decision making, but how can we use this kind of resource in the legal field where we're so used to gather ourselves in the concepts of what is good and what is bad, what is right and what is wrong? And once that we're delivering some decisions to algorithms that work processing a lot of data in multiple layers through a probabilistic approach, we also need to understand that once this is done, there is something in that decisional process that we lose. And this is called opacity. The decisional process that adopts algorithms at some scale is not fully transparent. And this is what allows us to miss some points of this decisional process. And at some situations, there might be errors in this process, there might be bias in this process, and we might have other kind of problems. So if algorithms take decisions based on the data they're fed with, if algorithms take decisions based on the way they are programmed, how can we expect that their decisions are fully scientific as they might seem at first sight if we live in a society that is biased? And that being biased, we can expect that this society produced biased data. We can expect that even if the programmers add very little information in AI systems, this information might also be biased by their implicit views. So we're talking about all of that in our panel, Legal Values and AI, Tensions Around Fairness, Accountability, and Transparency. And to investigate these issues related to fairness, accountability, transparency in AI systems, and how these situations interact with legal values like equal treatment under the law, we're receiving some great specialists. We're receiving Judge Paul Grimm, we're receiving Professor Ash, we're receiving Judge Khaled Ahmed, and we're receiving Dr. Angeline Wairegi. So now I'll start with a question to Judge Paul Grimm, who is a district judge for the United States District Court for the District of Maryland, and also a professor of the University of Maryland School of Law. Judge Grimm, I would kindly ask you, what should those who are listening to us know about AI? So which are the concepts and which are the basic dynamics of AI decision-making that you would highlight to a non-expert?
Good morning. Thank you very much, Judge Ferrari, and welcome to all of my co-panelists and all of you who are listening in. I think that what I would highlight for the key characteristics of artificial intelligence, AI, concepts and dynamics for people who are not familiar with it are sort of the following. First of all, I would highlight that artificial intelligence programs are pervasive in their current use, and that use is growing. We see artificial intelligence being used right now by decision makers and practitioners in healthcare, whether it's diagnostics using artificial intelligence technology that is supposed to be better than a human radiologist's ability to be able to read X-rays or MRIs, whether it's in robotically assisted artificial intelligence surgical tools. We see it being used in education in terms of analyzing educational data regarding test scores and tracking students through educational programs. Highly being used in employment, in the selection of qualified candidates from large pools of applicants. In transportation, where artificial intelligence is powering self-powered vehicles, not simply automobiles, but also aircraft and seacraft. It's being used in finance right now for predicting outcomes of investment strategies. It's being used to determine who is qualified to receive credit or a loan, either as a consumer or as a business. Extensively, it's being used in law enforcement in investigative techniques. It's being used, for example, for predictive policing to look at crime data to determine when a certain area is most susceptible to criminal activity so that police can be deployed when the highest need is there. It's being used throughout governments for example, for qualification of benefits for unemployment benefits or other government benefits. And it's being used in judicial systems in two ways, as our speakers have already said, and as Justice Ferrari mentioned. Number one, it's being used to help the administration of justice for court systems to use it to more effectively manage enormous amounts of legal information. It's being used, for example, in civil litigation to analyze gigabytes, terabytes, and exabytes of data in cases and try to analyze that in a way that will assist its use in the resolution of cases. And in some instances is being used as an aid to judicial decision-making. For example, some of the artificial intelligence software that makes predictions regarding recidivism and likelihood of committing future crimes. So the use is very pervasive. All right. So if we're using AI in all of these areas and the use is growing, what is the essence of AI that those who have not been immersed in this need to get a concept? Well, first of all, when we mention AI, there are really two or three concepts that come together. One is that AI is essentially the product of very sophisticated software programs run by algorithms. And an algorithm is nothing more than a formula, a step-by-step formula for how you accomplish a particular task. Now, algorithms can be written by individuals, humans. They can be written by machines, and they can be written by machines trained by humans or by other machines. Secondly, when we talk about AI, in addition to concepts of algorithms, algorithmic software, we're talking usually about machine learning, whereby either with the assistance of human training or by programming of the machine itself, or the machine simply looking for patterns and similarities or discrepancies, where the machine analyzes a large amount of data and makes certain decisions. And finally, it is frequently used in natural language programming. Think of your Siri or your Alexa or your other programs that are fairly sophisticated in interacting with humans. The key is that artificial intelligence is thought to be the use of algorithms in software programming to do functions that previously only humans could accomplish. And I think that when we talk about the use of artificial intelligence in judicial systems, as Justice Ferrari indicated, we're concerned about a number of things, whether or not it is the use of artificial intelligence in the administration of court systems to make them more efficient and to increase access, but also the use of artificial intelligence software applications as evidence that may be used to resolve civil or criminal cases brought to a judge or a jury to resolve. As Judge Ferrari said, we are concerned about bias in how the AI operates. Why is that? Because the artificial intelligence has to be programmed. It is programmed by individuals. We know that individuals may have explicit bias, but they also may have implicit bias, that they're not even aware that they are bringing to the programming process. The data that is selected to train the artificial intelligence software application may itself be biased. If the population sample that you use to train the artificial intelligence is limited to one segment of the population, one race, one gender, one age, one characteristic, then what it learns is based upon that, and it has a much less accuracy rate when you try to apply it to population groups for which it has not been trained. Secondly, many of these artificial intelligence software programs are privately developed by organizations or institutions that intend to license it to be used by others. They invest a significant amount of time and resources to develop it. It becomes their confidential commercial information that they have an understandable right to want to protect. And what happens is that they make the decisions as to how it is trained and tested to determine two key concepts. Is it valid? Does it accurately do what it is trained to do? And secondly, is it reliable? Does it consistently perform accurately across sample populations that are based upon similar data inputs? And since these are private, often private organizations, since there are not national or international standards for what is trustworthy AI or transparent AI, they're being developed, but they're not uniformly applied now. We worry about these concepts. Has it been tested? And if so, how can we determine whether it is both valid and reliable? And finally, we worry about function creep. which is a concern that happens when you develop artificial intelligence software to perform a certain particular function for which it is well programmed and trained and adequately valid and reliable, but then it starts being used incrementally for other purposes for which it was not intended. A specific example being the use of recidivism prediction tools, not for their originally intended purpose of determining what supportive services needed to be given to someone released on bail while awaiting adjudication of their case, such as mental health or drug treatment, but rather being used to predict recidivism for purposes of determining the length of a sentence to be imposed. And one of the things that we worry about, to address what Judge Ferrari was saying, is the level of accuracy that you must demand in artificial intelligence is directly proportional to the risk of an unacceptable outcome if you get an error in terms of what the output is. And I think those would be the main concepts that I would offer up to someone not especially familiar with AI, as it is a dynamic concept that affects the administration of justice. Thank you.
Thank you so much, Judge Grimm. I think you have perfectly highlighted in some minutes. I mean, the view on how our societies are changing because of AI in multiple fields and how it is getting to the legal field and the main points of attention. And to follow on this discussion, we're now hearing Professor Elliott Ash. Professor Ash is an assistant professor of law, economics, and data science at ETH Zurich Center for Law and Economics. And to follow on this discussion, I'll ask Professor Ash, what are some of the potential implications of AI in the law and in the legal system?
Thank you very much. So I have a few slides just to give a bit of more specific context to a lot of the really nice points that we just heard from Paul Grimm giving about a nice overview of the role that AI might play in the justice system. I want to point to some of my own research in the India judicial system, kind of zeroing in on issues of bias along gender and religion and caste, where, for example, only 4% of high court judges in India are Muslim, only 20% of district court judges in India are female, and there's also issues of overrepresentation in the incarcerated population of Muslims. And this issue is that if judges have some in-group or out-group bias or some prejudices that have often been observed in other contexts, this could create some discrimination in the India criminal justice system, notwithstanding that our goal in justice system is for justice to be blind and to treat people based on the facts of the case rather than their characteristics. So this is part of research with other researchers at Dartmouth, Imperial, Johns Hopkins, and the World Bank on in-group bias in the Indian judiciary, evidence from 5 million criminal cases. Just a shout out to the Indian justice system in terms of the availability of data. With the Indian e-courts platform is this amazing resource that is going to be influential, not just in making justice decisions more efficient and consistent, but also really boosting social science and analytics of justice. And we were able to download 80 million case records just from a 9-year period from this platform for all of India. This data is all of the cases from the lower judiciary, the district and session courts. This is just amazing to work on India, where just the sense of scale is so different, where you have 7,000 courts, serving 1 billion people. We also have very detailed information on the officers in the justice system. We have information on 8,000 judges, where they work, when they work, and some information on their background and their names. And this gives some really nice visibility and transparency on the judicial system, which has value on its own right, but is also really useful for when you're doing empirical social science research. And just one kind of quick first item that AI tools or machine learning can help in supporting research and understanding the judicial system is that we actually don't have demographic data on these cases. So we don't know, if we want to know, is there some bias towards women or men, or is there bias towards Muslim individuals or individuals during castes? We actually wouldn't be able to determine that from the data set because it's not collected, which is good from a privacy standpoint, but it's an impediment to research. And so we actually built an AI-based, a neural network-based classifier that can be applied to the first and last names of the defendants or the lawyers or the plaintiffs, other actors in a case, and learn with 97% accuracy the gender or religion identity of the individual. And so this is something that we built open source software using open source data, and we put this classifier online. We then made anonymized data. So we took out the names, and we wouldn't want to, I think that would be a violation of privacy. All of this is public data, but we don't want to make it too easy to search through everybody's names. We anonymized it, added in the gender annotations, and made an open data set for everybody to use. This has since been used in a number of other research and some blog posts and things like this. I think the fact that India made the data available and we were able to use it for research purposes is really great. So we took this data, we looked for bias towards along gender or religion margins, and we actually didn't find much evidence of it. So this is actually quite encouraging, given like the anecdotal evidence that there is a lot of bias towards women and Muslims in Indian society. It seems like that bias isn't happening at the level of judges making decisions about whether to acquit defendants in criminal cases. We did find some evidence of different religion bias during Ramadan, and we found some evidence that judges might favor defendants from the same close cultural group or close caste as proxied by having the same last name. But overall, we have some optimistic evidence that in the Indian justice system, some equality and is guaranteed. So I think that the upshot of these is that data science tools and AI are going to have implications not just for judge decision making, but for scientists and policymakers interested in understanding the justice system and judge decision making. It also opens up many other questions. So if there isn't bias among judges, where are the biases coming from? And for example, we're using in future work some of the natural language processing tools that Judge Grimm mentioned applied to the sentence orders that these judges are giving to understand, is it coming through the harshness of the sentences, for example. So I hope this is a starting point from the social science perspective that will lead to further discussion along with the other panelists. Thank you.
It is indeed a great starting point, and it reminds us of something that many people forget when we're talking about opacity and bias in AI decision-making. And the point is, of course, we need to discuss and we need to be worried about that. But when we have like human decision-making, at some point, our decisions, ours as judges, they also have some level of opacity. We here in Brazil, there is something that you say that you never know what goes on a judge's head. And of course, there's also like bias in the heart of judges at some level due to our position in society. So when we make this change in several fields of life, from human decision-making to hybrid decision-making, combining humans and machines, we might have the opportunity to think about these human problems of opacity and also bias. And we might have a chance to make the necessary corrections on that. So now we welcome Justice Jasmeet Said. Justice Said is a judge of the Delhi High Court of Law. And after welcoming him, I would ask him kindly to tell us how or Indian courts using AI to support judges, and if there are ways to help us to get to rulings quicker and in a more fairly way. Good morning or afternoon or good evening, Justice Side.
All right, thank you. Good afternoon to everyone, to all the panelists and the respectable judges. So at the outset, what I would like to say is that in my I was a lawyer before I became a judge, and I had a practice of about 30 years. And thereafter, I was elevated to the bench. So in my experience, as far as the judges are concerned, I have not come across instances of bias. I would just say that as far as the judges are concerned, I have bias towards women or Muslims or particular caste or particular, India is a land of religions and castes. But in my experience as a lawyer or as a judge, I have not come across instances of bias, so as to say. Judges may have views. They may have different, different ways of handling a particular issue, but bias would not be the word I would be using here. Having said that, on the issue of artificial intelligence, so India is embracing artificial intelligence in a big way. So our honorable minister has expressed the need to adopt the cutting technologies of both machine learning and artificial intelligence to implement the e-courts. What we have at the High Court level and at the Supreme Court level are now the e-courts. Delhi High Court, there is we are on an e-portal wherein there are no paper files anymore. Everything is e-filing, it is e-documented. The lawyers are on their are using e-technology. So that way, we are embracing the e-technology in a full and a meaningful way. Now, what has happened in the Supreme Court is that there are two programs which have been implemented. One is called the SUPACE. So it is a artificial intelligence powered workflow, which is divided into 4 parts. One is a file preview, one is a chat box, one is a logic gate, and one is a notebook. The files are available in PDF forms, which are converted into text. The text and then voice-enabled chat box helps to give an overview of the case. The extraction system gives information about the case and the chronology, the precedents, the judgments. And then what happens finally is an integrated word processor makes the end-to-end system, and it is used by the judges. Similarly, there's another software called SUVAS, which is Supreme Court Vidhik Anuvad software, which is again an artificial intelligence system, which helps the translation of court decisions into numerous regional dialects. So again, these are the systems which have already been implemented by the Supreme Court, which is the highest court of our country. Now, what I feel, which is what has been emphasized, is the bias of the artificial intelligence system. See, end of the day, artificial intelligence system is based upon the data that is fed into the intelligence system. Let me give you an example. When India gained independence in the 1947, there were a lot of migrants who had come to Delhi, and it was felt that there are people who are unable to own properties, and they would generally be on rent and on lease. So therefore, it was felt that these people needed some extra protection, and there was a legislation called Delhi Rent Control Act, which was a legislation of the 1950s. Protection was given to the tenants that they cannot be evicted until and unless there are 3 or 4 grounds. Then in the year, with the passage of time, it was felt that all the tenants have been settled in Delhi for about 40 to 50 years, and now they are no longer requiring that protection. So the judicial trend was from pro-tenant, it was shifting to pro-landlord. Now, if we take the entire gamut of rent control legislation, so about 70% of the cases would be pro-tenant, and 30% or maybe 25% would be pro-landlord. Now, if that is all fed, the result would still, even in today's time, when the entire conspectus has changed, would be in the nature of pro-tenant. So therefore, there is a bias because of the data that is fed into the system. It is only going to be analyzing the data that is fed. But having said that, again, according to me, artificial intelligence can go a long way, where we have something like one judge for about a million people, that the person, before he goes to court, before he knocks on the doors of the justice system, must know factually or reasonably that where he stands. If there's an artificial intelligence system that provides him that in such kind of cases, this is the success rate, this is the time you will involve yourself in litigation, the decision of the person who goes to court may be different. He may choose, she may choose not to go. He may choose alternative dispute redressal, like a mediation process. You see, so that would go in a long way in reducing, according to me, in reducing the number of cases. If a person already knows that in a similar kind of a case, this was the outcome, this is the time it took, this is the cost it took for the person, the decision may be different. So that way, artificial intelligence, according to me, would go a long way. Artificial intelligence would also go a long way in kind of drafting contracts. Your lease agreements, so that, because that is not something that is something which does not require a human or a humane approach. There are contracts, you feed in the data and you can get pleadings, the lease documents, the contracts, that all can be done through artificial intelligence. But according to me, again, artificial intelligence is the new technology. We must welcome it. It is change for the better. It is change of the future. But to say that it can supplant judges, it cannot be. It can only supplement. It can give you the data. It can give you precedents. It can give you the issues, how it has been decided by other courts, what is the perspective, but only to supplement. It can never be to supplant. So that's my view. Thank you. Thank you very much.
Thank you, Justice Said. And it's interesting to see when we talk about AI decision making, it's interesting to realize that we're talking about decisions that are based on data that has previously fed the machine. And when we're talking about decisions based on previous data, we're talking about decisions that are based at some level in the past, because this data is in the past. So as Justice Said said, it's important to state that we shouldn't expect, I think in any of the fields, that AI would completely substitute humans, take our positions, because every time when there is the possibility that a new decision must be taken because the situation is different or because a new problem has arisen, for these two situations, the state of development of AI that we have nowadays, that is like weak AI, it's not a grand intelligence, it's not strong AI, it's just weak AI that is trained to solve specific problems. For this situation, every time that you need a new decision, a creative decision, or every time that you look to a situation and think it's a different situation, it should have like a new answer or a creative answer, or this is different at some level from everything that we have seen before. For these situations, AI can't help us. It can help us in the huge amount of situations that are just repeating previous facts or previous situations, but for new solutions or for this act of distinguishing, human view will always be needed. And to go on with our discussion, we're now receiving Dr. Angeline Wairegi. Dr. Wairegi has a PhD. She's a senior research fellow at the Center for Intellectual Property and Information Technology Law. And she's also a co-director of the Center for Intellectual Property and Information Technology Law, Data Governance Policy Center. Welcome, Dr. Wairegi, and I would like to ask you if you could highlight some ethical concerns for us that should be evaluated upon the adoption of AI in legal systems.
Thank you so much, Judge Ferrari. Please let me know if my audio dips in and out. And I will be referring more specifically to Africa because most of our research in AI and also within the data sphere has an African perspective. And another caveat is I will say Africa, but I would like to really stress that it's not a homogeneous entity. It's just easier to say Africa in this case. That said, the continent dipped its toes into the AI pool a little bit later than elsewhere around the globe, specifically referring to AI activity in the EU, UK, and in the States. That's a little bit more developed than it is here. But we do have an emerging AI ecosystem. And by that, I mean, we do have AI activity in terms of end users. So people are adopting the tools and using them. And we do also have AI developers emerging from the continent. So if you were to take a look, you would see that we have a number of applications that have been developed and deployed in the continent within certain sectors. That does not really happen or is not currently happening within the legal system. So all of the tools, at least from our research so far, that have been deployed within the judiciary, let me not say all, most, that have been deployed within the judiciaries have been imported in. There are a number of AI tools that are being utilized in legal firms that have been developed in Nigeria, for example, has 2 AI systems that have been developed and are being used within Africa, within the legal firms. But within the judiciary, most of the tools that we're seeing have been imported in. And that's just the general trend that we see in Africa. Again, very general statement, but we tend to be more importers and consumers of these texts, and then we tend to export our data out. That leads to 2 large concerns I'd like to talk about. One has already been touched on, is the issue of bias. We know that AI platforms are human endeavors and they're coded by human beings and they are trained with data sets that are compiled by human beings. If all of this activity, if all of this foundational activity is being done elsewhere, and then we're simply importing those tools, they've not been specifically localized and contextualized to the problems within the African continent or within a specific nation in Africa. I mean, there's a little modification you can do, but then the question is, how much does that help? Right? So issues of bias are, you would think, are almost inevitable in a case such as this. So we're using tools from elsewhere, and we're trying to sort of rig them to work within our specific context. I mean, there's something we could do maybe to mitigate those issues, but I would think right off the bat that that would be a primary concern, that there would be bias in there. The other one I'd like to touch on is issues of access. So access, I mean this in the broadest terms. There tends to be a large disparity in terms of financial resources, in terms of digital resources, in terms of digital knowledge and digital literacy. And this tends to be seen across the board. I can speak specifically for Kenya. We have a massive rural-urban divide, I think, across all sectors, across all values, across all aspects. So if you're looking at Nairobi, for example, which is where I'm based, access to internet, access to technological tools, things like cyber cafes, they're very prominent here, right? So if you transfer that gaze to some place that's a little bit more remote, let's say in the northern eastern parts of the country, then I don't think you see a lot of Wi-Fi towers right around the villages, and things like cyber cafes are a little bit more sparse. So we could deploy these AI tools in the judiciary with the intent that they would ease issues of access, but then the question arises, is that really feasible given our current environmental setup, given our current digital setup? Also, the disparity runs within the judiciary as well. Kenya has an ICT strategy to ease the case backlog in the Kenyan judiciary, and this was deployed and implemented in 2017. But before COVID, what we're seeing is a lot of these ICT functions, a lot of these ICT policies were only being enacted in the major cities. So Nairobi, Mombasa, Nakuru, like the really big cities, you would see judiciaries where they had been a concerted push to really, really invest in their ICT tech. But what happened during COVID is we all went on lockdown, and the disparities between the judiciaries in the urban counties and the rural counties were really, really stark. They really, really came to the forefront. And the government had to, within a very short timeline, really put in a lot of money, a lot of time to also deploy these tools in the rural areas so that citizens could still have access to judiciary services. So that's another thing what we need to consider when we talk about access. Is this equitable across the board? And then I will talk about literacy and knowledge as one lump, although they're not really. But in terms of digital literacy, really meaning at the very basic level, can people operate these tools? Do people know how to, from a mobile device or from a laptop, go onto the website and navigate that entire thing? That, again, there's a stark difference in digital literacy when you look at people in urban areas versus rural areas. And then digital knowledge is, I think, a step further than that. Yes, you can know how to navigate, but do you know the full impact of using these tools, right? We talk a lot about data justice within CIPIT's Policy Center. And a big part of that is knowledge. Do you know how your data is being used in terms of how whatever data you put out there may be used by these systems within the judiciary to adjudicate your case, even if there is like human help in that process? And also, do you know how your data is being stored and processed in terms of privacy issues? That can come and bite you back. So data knowledge, I think, is also very asymmetrical. The people who work in this field, the people who are a little bit higher on the social economic ladder tend to have a little bit more interaction with data and maybe a little bit more knowledge in terms of the impact of how these systems can and are being used and how it can impact them. So when we talk about ethical and responsible AI in the judiciary, I think that's really two of the biggest things that we're concerned with. Bias, because everyone needs to know that they're being adjudicated fairly, and then access. It's all well and good saying that these tools will help, but if it's only people within a certain status quo that are able to access them, then people in vulnerable groups don't benefit as much. So I think those would be the two biggest issues ethically that I think we need to discuss. Thank you.
Thank you so much, Dr. Wairegi. And now that we're really concerned about everything that she said, we're hearing Judge Khaled Ahmed. Judge Ahmed is a senior rule of law, United Nations qualified legal practitioner for the last 28 years, has been a public prosecutor for 5 years, and a judge for 23 years. And I'd like to welcome Judge Ahmed and ask him, that is a person that is highly experienced in the implementation of justice reform programs in the region of Middle Earth and North Africa. If he could tell us some of the benefits of that AI might bring to judicial systems.
Thank you, Judge Ferrari, and thank you for the organizers for this kind invite. I am happy to be here with you. Do you hear me well, since I'm talking from a UN compound in the middle of the desert, so our internet is not always stable. So do you read me? Okay, all right. So in order to answer this question, I should say that let me start by giving you an example of what's happening on the ground so that everyone would understand how beneficial is the artificial intelligence to the Arab judicial systems. Also, I would like to talk about the main obstacles that Arab judicial systems are facing. First, to start with, there is a severe backlog of cases in most of the Arab countries. So many reasons for that. One of them is the shortage of manpower in all judicial systems without an exception. Third, and most importantly, almost 17 out of the 23 Arab judicial systems are still using handwriting instead of electronic means. Therefore, when you talk about artificial intelligence in those systems, you're talking about black and white. You're talking about day and night. It is noteworthy to say that artificial intelligence was introduced to most, if not all, the Arab countries because of the COVID-19 pandemic. We now see most of those systems using Teams and Zoom to review detention orders instead of transferring detainees from prisons to the public prosecution. Here in Libya, we use the same techniques to conduct virtual court hearings because the court system was shut down on the 15th of March 2020 for 6 months. We had more than 7,000 people stuck in prisons, either on pretrial detention or did not even conduct the investigation yet by the public prosecution. So it was really important to assist the judicial system to overcome those difficulties by using some basic and simple elements of artificial intelligence. Another example of the use of artificial intelligence in the Arab judicial system is Dubai. Nowadays in Dubai, they are using the e-justice techniques in a very advanced manner. All court documents and investigations are electronic. When interviewing a witness or a victim that does not speak Arabic language, they use this system that provides spontaneous electronic translation it's almost, according to the Ministry of Justice in Dubai, it provides 99% accurate translation from 6 different languages into Arabic. And it is printed in the hand of the prosecutor or the judge immediately. They're also using e-systems that provide analysis of the information contained in the database. We do not have such example in the other 22 Arab countries. Only Dubai that does that. At this time, most of the Arab judicial systems are considering gradual introduction of artificial intelligence into the judicial work. We see countries in the MENA region already started to implement using advanced technology to type the court records or the investigations or for the translation. We are using computers being used more oftenly. We are seeing a lot of advancement in the treatment of prisoners inside places of detention. These are all small, shy samples of the use of advanced artificial intelligence within the judicial system. The reason why I described it as shy is that most of the judges and prosecutors are skeptical about, is this artificial intelligence going to replace judges? So this is actually taking place at this time, delaying some of the progress in the way of using artificial intelligence in some of the Arab judicial systems. We're trying to deal with that through dedicated programs to increase the capacity, to increase the knowledge of judges and prosecutors and officials at the level of ministries of justice, to try to make them understand that one way or the other, you will end up using artificial intelligence, simply because artificial intelligence nowadays, when it is actually implemented in Dubai, you would see the difference in the backlog. You would see the advancement in the economic courts that they established only for the purpose of promptly giving rulings or decisions in such cases or complaints. And then when they introduced the artificial intelligence, they started to see a lot of indicators that are simply being described as incredible, because judges nowadays are using those techniques to analyze the database before them. For example, a judge sitting in Dubai ruling upon a conflict between a company that is based in Turkey and another one that is based in China for a transaction that was conducted on the soil of United Arab Emirates. They are able to extract information from the database very, very fast and use that data to decide what to do with the case. How can they promptly implement the ruling itself is another issue. They are using all possible means that provides to them up-to-date information that is facilitating to them issuing rulings, court decisions, and also assisting public prosecutors in the way they conduct their investigations. This is simply how artificial intelligence is important to judicial systems in the Arab region, and I'm happy to take any questions. Thank you, and over to you, Judge.
Thank you so much, Judge Ahmed. It's interesting that you mentioned backlog. And I think that the Brazilian situation, the country where I live, is one of the worst in the world when we look at the relation between backlog and population. We have nowadays 78 million lawsuits of backlog. I remember I've been in an event with Professor Richard Susskind around 2018. I think that, just to make a comparison, India by that time had something like 30 million lawsuits of backlog. And Brazil has had by that time around 90 million. Now we have a little less. So in this environments, when you have a lot of backlog, like looking at technology is a way to try to deal with this. And perhaps because of our special in the bad sense of it, perhaps because of our special situation, Brazil is one of the countries of the whole world that has more initiatives of AI in the in the judiciary. Nowadays, we have around 64 projects in our country, projects that are related to very different things, from dealing with the lawsuits, identifying repetitive lawsuits, to suggesting laws that should be applied to judges, up to drafting decisions. So it's really something, isn't it? And when we see this scenario, we start thinking about some of the legal values that might be tense by AI, by artificial intelligence. And to talk about this issue, about the legal values that might be tense by AI, I would call again Judge Grimm to share some ideas with us.
Thank you, Judge Ferrari. And I have been listening with fascination to the comments of all of the speakers. And it is reassuring, I think, to hear that from whatever part of the world judicial scholars and practitioners look at how we can better serve the public that we are required to serve, that we're all observing similar issues and challenges, and seeing the hopeful possibilities for the future, which I hope through programs like the one that we're doing now causes a great deal of cooperative exchange, such as already has been going on in this program and other programs sponsored by UNESCO and the other organizations that have put this program on. So we have a tension, a natural tension that develops between competing doctrines in a judicial system. So, for example, we have thoroughness of decision-making versus speed in rendering decisions. There's a well-known expression that justice delayed is justice denied. When I first became a judge nearly 26 years ago, I was told that the imperfect decision that I render today is better than the perfect decision that I never have time to get around completing. So we have various tensions that require some sort of a balance. I'll give you one specific example that comes up a great deal in artificial intelligence. You have a very strongly held principle in most judicial systems of due process, fair process. Fair process means that the litigants have access to sufficient information, that the procedures give them notice of what they must deal with in the case, that the mechanisms ensure fairness and a balance, and that it provides a decision as quickly as possibly can be done. In the federal system, the rules of civil procedure in the United States say that the rules of procedure are to be employed to secure the just, speedy, and inexpensive resolution of all cases. So we have due process. I need to know. I want to challenge this evidence against me. I need to know how the evidence operates. So let me have access to the information so that I can come up with a challenge, particularly if the information is based upon artificial intelligence software technology. I need to know how that works to be able to know whether it is valid and reliable, whether even if it is methodology that's valid and reliable, whether it's been reliably applied to the facts of this particular case. And if we look through the lens of due process, we would say, well, that's reasonable. We should encourage that. On the other hand, there's a competing interest of trade secret protections. All of our speakers understand implicitly that the development of artificial intelligence software technology is not always done with open source programming like Professor Ash was talking about, but oftentimes is developed commercially and by entities that want to capitalize and monetize their artificial intelligence technology. I'll give you a specific example. Within the United States, one of the techniques that is being extensively used in criminal cases, both to secure prosecution convictions when that is where the evidence leads, and also to show, to procure results of acquittals or to determine when someone has been unjustly convicted, focuses on DNA analysis. There are very sophisticated software programs that are being developed and used regarding probabilistic genotyping that use very sophisticated statistical algorithms to analyze the DNA alleles from individual or multiple donors on a particular item of evidence, and to then create a probabilistic estimate comparing the likelihood of some random member of a particular population having left that DNA as compared to the sample that was taken from a suspect. These programs have been used in about half of the states in the United States, in both federal and state courts. Whenever you have a criminal case, it is not unusual for the defendant through counsel to say, now, wait a minute, we need to have the software. We need to look at how this operates, because this is all statistical analysis. It's very complicated. One program has 170,000 lines of computer code. We need that code. We need to look at that code. We need to be able to see whether there are errors in the coding that might affect the output, because if the jury hears that there is a 1 in quadrillion chance that someone in the population other than this particular defendant is the source of that data found on the evidence, then that's it for the jury. They're going to say, this is the person who was there and this is the person who was responsible. But what oftentimes happens is that the developer of the software, analytic software, has licensed that to all of these crime labs and these law enforcement organizations, says, if I give up this code that I have developed over 25 or 30 years and have tested, and I can demonstrate through validation studies that it works, then my competitors can take the benefit of 30 years of my own hard work and labor and use it against me. And we have seen cases in the United States in which some courts have come out in favor of prohibiting the disclosure of trade secret information dealing with how artificial intelligence systems operate for protection of that commercial property of the software developer. Other courts have said, no, we come out in favor of due process. You can't have it both ways. You can't use this evidence against someone, particularly when it may be highly prejudicial to them, without giving them an adequate opportunity to be able to challenge it. And so how do you strike that balance? And that's emerging. You have cases where, for example, you have some courts have experimented with using protective orders that give a certain amount of access to the software without disclosing the code so that it can be fairly tested. So we see these competing notions, due process versus trade secret protection. Secondly, the tension with legal values. I think that all of our speakers have sort of touched on this in one sense or the other, is that AI programs are so sophisticated that we're never 100% certain how they operate. There's an issue of transparency. In our legal culture, we have this notion of transparency. We need to be transparent. If a judge rules, a judge must explain the basis of their ruling so that the higher court can evaluate whether or not they ruled in error. We need to have transparency in our evidence. We need to have transparency in access to information. There is oftentimes a question for artificial intelligence software programs, just how transparent they can be. And you hear that in phrases such as, is it a black box? We don't know how it operates. We feed data in, we get output, but we don't know what happens when it gets in there because the data has been trained by a human, but then has analyzed the data that it looks like and then trains itself by making adjustments in how it operates to look for matters that perhaps the programmers can't even explain. So is there a way, I mean, does every box have to be crystal clear so that you can see how it operates? Or can you have, how do you have sufficient transparency to rely upon the output? What are other legal values that can be in tension when we talk about artificial intelligence? Well, obviously, the computer scientists and data scientists are familiar with the acronym GIGO, garbage in, garbage out. And as Justice Ferrari and other speakers, Judge Ferrari and Justice Singh and Judge Ahmed have said, we are trusting on the programming of this artificial intelligence to give us reliable results. But what do we mean when we talk about reliable results? We mean that the artificial intelligence has been programmed and tested sufficiently so that it is acceptably valid, meaning accurate, for a particular use, and that its validity has been demonstrated across a sufficient number of trials on like data so that we know that it is reliable. Validity means accuracy, and reliability means consistency of accuracy when applied to similar data. But we don't have any one level of minimum threshold of validity or reliability. Judge Ferrari talked about, 99% accuracy. And I think that other speakers have talked about a high percentage of accuracy. And you might say, well, geez, 99% accuracy is perfect. There's such a small error rate here that, of course, it's got to be good. But the answer is that there's no one threshold minimum accuracy level, depending upon what you're going to use it for. I'll give you two examples. If you're using artificial intelligence software programs to determine how long a sentence to impose on someone who has been convicted of a crime, and you want to deter them from committing future crimes, and you want the sentence to be long enough but no longer than necessary to do that, if you have artificial intelligence powered predictors of whether they will recidivate against, and if the risk of getting it wrong is that someone gets a 20-year sentence instead of a 2-year sentence, then you need to have a higher confidence level that the programming is such that it doesn't have the type of bias or programmatic problems in it to produce an outcome that is not acceptable. So in that particular case, you might say, well, I don't know, 90% is not good enough. We don't want 1 in 10 cases producing an unfair sentence. Now look at it from a different concept. Let's jump from law for a moment and let's look at medicine. Let's say that we have a person who has been diagnosed with a terminal illness and told that they have fewer than 6 months left to live. They are also told that there is an experimental, not yet approved for public use, medication that has a 60% likelihood of completely curing them, but a 40% chance of killing them. Now, most cases, you would say that 60-40, there is a pretty significant likelihood that that person will die. They'll be in that 40%. It's almost 50-50. But there's a 60% likelihood that they may be cured. Is that an acceptable error rate? Well, from the perspective of a person who's been told that they only have 6 months to live, they may be willing to accept that 40% chance of passing earlier as an acceptable trade-off for a 60% chance of being cured. And so what that illustrates is that we have these tensions in terms of risk of error, which pushes us toward higher and higher and higher demands for validity and accurate and reliability demonstration. But at the same time, we need to realize that for certain types of decisions, you don't have to get it perfect. You just have to get it good enough. And there's an old expression that the perfect is the enemy for the good. So that can be an area of challenge. The final area of challenge that we want to realize is this. Judicial systems operate under rules. We're rules-based systems. We have rules of substantive law. We have rules of procedural law. We break things down into sequences. And whenever we have something which is scientific or technical, we want to deconstruct it to be able to know, well, what has to be shown before we can say that it's sufficiently reliable to be able to use in determination of cases, civil and criminal cases. So we talk about adequacy of data input, the reliability of the methodology, and whether the methodology has been reliably applied. We talk about error rates. We talk about whether it's been tested, whether it's been subject to peer review analysis, whether the methodology used is recognized by others in that area of science and technology as being sufficiently reliable. And we love to have this kind of hard quantitative support for the fact that we can use it. But the trouble is that with AI, we are just at the very beginning stages of determining what standards are minimally acceptable for AI, which is sufficiently transparent and sufficiently reliable. And those are beginning. In the United States, for example, the National Institute of Science and Technology, which is abbreviated as NIST, highly respected scientific analytical arm of the Department of Commerce, has recently gone to the American Association for the Advancement of Science and asked them to help develop various benchmarks for trustworthy AI to be used in judicial decision-making. And there is a panel of data scientists and computer scientists and those in the judicial area who have been working on those standards. I am on that committee. And those standards will come out, but we're still, at least in the United States, several years away from having standards that can give us that confidence that we have adequately determined validity and reliability. This is going on, I think, maybe at a more accelerated pace in other parts of the world, in the EU and maybe elsewhere. But this notion of certainty versus expediency is also a tension that we see in artificial intelligence. And so these are some thoughts that I have about what tensions there may be with this promising new technology and the legal values that have shaped systems of justice throughout the world. Thank you.
Wonderful, Judge. Thank you. And now we're going back to Professor Ash, and I'll ask him how can we reach algorithmic fairness when the data that is used to train algorithms is produced amid biased societies and therefore might reflect this underlying discrimination. Would you talk a little bit about this for us?
Is that working now?
It is.
Great. Thank you, Judge Ferrari, and thank you, Judge Grimm, again, for the really nice follow-up to many of the issues that have come up so far. I wanted to bring things again to an example context. A lot of the issues in kind of AI fairness and AI bias have come through in general terms, but another example of the value of open data is the Wisconsin Circuit Court's access data set, which has public case records and docket information from 72 county courts starting from the 1970s. Through this data service, we were able to compile 11 million case records, or 2.5 million criminal case records, including information on the defendant, the name, different identity characteristics, as well as the associated judge and legal officers, and really detailed information on the cases in terms of bail hearings and amounts, sentencing, probation, incarceration, parole, and many other events. And this is going to help us get at predicting recidivism or predicting probability of recidivating in exactly the way that Judge Grimm was talking about. In this previous paper with Nian Yun Lee and Naman Joel, we analyzed a lot of the kind of issues that have been conceptually discussed about issues of data and issues of potential bias in the data, getting into these recidivism risk predictions, and what the potential problems that could be caused by that if you try to use this for decision making. So we built a recidivism model and looked at a variety of different features, including current events, criminal history, some characteristics and age, and then trying to predict, as is done in these standard approaches like COMPAS, is trying to predict if the defendant is rearrested or is back in the criminal justice system within 2 years. In terms of the machine learning algorithm, this is, I liked what Judge Grimm said earlier about actually, these are extremely complex, sets of rules, go this way, go that way. XG boost or extreme gradient boosting is that. It's actually a complex collection of decision trees that split on different values of predictors and is known to get state-of-the-art performance on recidivism risk prediction and other related tasks. That being said, it is, I think this is the best way to do this prediction, but it's not, that accurate. It's like 65%, 70% accurate in predicting whether a defendant will commit more crimes in the next 2 years. What we can say is that it ranks the defendants quite well, where if you're in the top decile of recidivism risk, according to our algorithm, you have, let's say, 75% chance of ending up in the judicial system again. If you're in the bottom decile, it's less than 20%. And so it really can identify people who are at higher risk, but for any given individual, the accuracy is not that high. It will make many errors. So you aren't going to want to make decisions just based on this, right? As Justice Singh said earlier, to the extent you want to use these tools, it's going to be supporting a human decision maker, adding more information and helping to organize it. I wanted to point at some of the issues of bias that come out of this data set and analysis. If we rank the defendants by their recidivism risk, we can see that across the distribution, African American defendants are put in jail at a higher rate than the other groups. So I think this is kind of helpful from a social science or policy perspective, because we can see that, to the extent there are these disparities in decision making towards different groups of defendants, it's not just because they have a higher risk of incarceration, at least according to our machine learning model. So judges or the justice system more generally are using some additional information to make those decisions, resulting in some large disparities in jail rate. I also wanted to, so this is like, some evidence of some potential human bias, but I also wanted to point to machine bias. In this paper with Lee and Joel, we considered how changing somewhat arbitrary aspects of the training data could have really large consequences in the outputs of the model. So if you just use data sets from different years, you get very different accuracy. So like this is like 2001, 2002, up to 2014. And not only does the accuracy or error rate differ over time, the relative treatment of different race groups in the data change. So, for example, if you use data from the early part of the sample, you get higher false negative rates for race minorities. But if you use later years in the sample, you don't see those differences. And so the fact that kind of disparities in algorithms could change by these, somewhat arbitrary differences in the data, I think give you some pause and how they're constructed, and will motivate, you want to ask some careful questions, not just about our kind of open source algorithm, but also, of course, the private sector algorithms, which they might be difficult to audit due to these trade secret issues. So, just to wrap up, both humans and machines can be biased, but I hope that this short presentation has exemplified how AI tools can also be used to diagnose and hopefully mitigate those biases for both humans and machines.
Thank you so much, Professor Ash. And I think that Judge Grimm and you brought insights on a question that is one of the central questions, that is, once we realize that even algorithmic decision making makes errors the same way that humans make errors, in which fields do we want to, do we accept the errors that are a result of a machine, and in which areas should we only accept the errors that are made by humans? I mean, in which fields we prefer to have a human judge making an error and we wouldn't accept a machine making mistakes? I think that in the criminal field, especially when we are talking about freedom, we're in a forbidden area for an algorithmic decision making. I don't know. This is one of the biggest discussions that we have nowadays. And also, once we realize that there is bias on data, how should we intervene? I mean, which would be the best technique of data messaging to clean this data of this bias? This is also an open question. And to go on with the discussion, we're going back to Justice's side, and I would kindly ask him, how do Indian courts deal with social cleavages like gender, religion, socioeconomic status, and caste? And how in India do judges try to treat everyone equally under the law?
That's a very, very basic question. So as far as I told you, I mean, as far as I see and what my experience has shown me, in the judiciary, in the judicial system, our constitution, the very fact that we devote the judges from the subordinate, from the trial courts, devote so much of time on the cases, just kind of ensures that it is devoid of at least I mean, that is the endeavor, that it is devoid of bias, it is devoid of partiality, it is devoid. So that's an ingrained. I mean, why India? That's a common thread through all judicial systems. The idea is to do justice, and the justice cannot be done if there's an element of partiality, if there's an element of bias. So as far as that is the oath every judge in the country takes, and according to me, every judge lives by that oath. So absolutely, I mean, I have no doubt, even for a 0.1%, that is the basis or the basic trait of any judicial system. Absolutely, I have no doubt on that. So I mean, human error is something which is, again, when humans are sitting, they make errors. There is a hierarchy of courts. The errors are supposed to be corrected at the higher level, but otherwise, I have in my experience, as I told you earlier, I have not come across any instance of bias, partiality. But yes, views, your convictions, they definitely come into play, because you see, you have to decide, you have to adjudicate. So definitely there are your views which will help you to adjudicate. So that is what I feel. So
thank you, Justice Side. And Vlad Grigorescu has brought something to the discussion on the chat. He said, hello, don't you think that to eliminate any error, we should use the software only to identify ideas, reasoning, solutions, at least at the beginning, for us professionals to check and avoid using the software for making decisions? And his suggestion is something that many people highlight, this idea that we should have a human on the loop, always, like a human instance that would review or that would adopt the last decision. But when we talk about the human in the loop or the judge being assisted by an algorithm, we should always remember what is called machine bias, a human tendency to adopt the solution that the algorithm suggests, just because we feel this decision that the machine is suggesting as a scientific decision. So putting a person to the side at the end of the process does not solve all of our problems because of the situation. We see the solutions that algorithms, that machines tell us that we should adopt as scientific ones, but as we have seen during this morning in Brazil, afternoon in other places of the world discussion, machine decisions, AI decisions, they're not properly scientific because they're based on data, and this data might be biased, might have mistakes, might have incorporated like these human aspects. Not only the data, but the way you program algorithms in a way brings your view. So it's not a solution that would solve all of our problems, but it is one of the ways that people suggest that we should proceed, at least in this initial moments that we are adopting AI to take more intrusive decisions, let's say so. Okay, so now we follow our discussion, and I would go back to Dr. Angeline Wairegi, and I would ask her a broad question. I would ask her what she considers to be some of the specific legal values that are attention by AI in the African region, but also how data centricity can help empower African citizens and communities. So the bright side and the bad side.
Thank you. I think I'll start with the tension question, because I think most of what we're seeing on the continent has already been touched on, and it mirrors decades of illegal tensions that have been here. So what we see with technology is it tends to either, or what we've seen globally, I should say, with technological revolutions, it either tends to classify or calcify, I should say, existing inequalities or widen those inequalities. And I think the fear is that AI will behave in much the same way if we don't take steps to prevent that or to mitigate that. So again, what we have in Africa, speaking in generalities, is we have this disparity in social economic resources. And that is on a higher level and also on a granular level. There's sort of a trickle down effect. So if you're higher up in the social economic ladder, it means you have access to education, right? And if you have access to education as a whole, and you have access to better education. And that means in this better educational institutions, you can get training in digital and data matters. So how to use computers, coding, all that stuff. So what tends to happen is two things. One, from the end user, you'll have a certain segment of the population using and benefiting from these tools, whether it's AI or ICT tools as a whole. And then the back end, you'll have a certain segment of the population that is involved in development, and they carry that bias within that population throughout that process. So we did a study at CIPIT a while back, in 2020, that was looking at the gender disparity within the emerging AI workforce. And what we saw is, one, it kind of mirrors the global gender disparity in tech, but it's a little bit worse actually. And it tends to get worse as it as the positions of power. In the higher seats of power, you find that 90% of the people in those seats of power are men. And they're men from higher economic levels. And that really affects how AI is developed. If you, for example, don't have women in these conversations around how they're developing these tools, then a lot of the factors that go into developing them, a lot of the factors that should be questioned or voiced or concerns by women, I'm just using women as an example, those are not really raised. And it's sort of, it would be naive to think that this would not be the same thing that would happen if we were to develop local tools to be deployed within the judicial systems, right? So we'd have to make sure that this was really inclusive. Again, we have issues of resources in terms of digital infrastructure. There has been a push by the Kenyan government to make sure that we don't have such a disparity, such a skewed such skewed digital development between the rural and urban areas. But even now, we still see, even if we look at just like mobile tools, in the urban centers, you have 4G towers for mobile tools. But if you go to the rural areas, you have very few of those. So yes, there's been a lot of mobile penetration in Kenya, in Africa in general, but you see that there's also a disparity in the types of mobile equipment that people have access to and that are available. So if we're going to say we're going to deploy this AI tools for use in the judiciary to ease access, okay, that's great. And we might even make sure that these tools are mobile, they can be used in mobile devices, but is it really realistic if you have people in the rural areas who only have access to 3G mobile devices, right? That's problem number one. And they barely have internet connectivity. Is it really realistic to think that this would ease with their issues in getting justice? So that's a concern as well. The other concern is, and then I'll move on to the issue of data centricity. I guess the power asymmetry in terms of we believe, and there is evidence to show that as a whole, justice is carried out fairly evenly. But even getting to the legal system is a matter of justice in that it costs money to hire a lawyer, right? It costs money to take time off to go into the court systems. And we can't really be sure that there isn't bias in terms of people who are politically connected or a little bit more higher up in the economic strata, that doesn't carry some weight in how whoever is deploying this justice views this litigants and how they rule for or against them. So what would be the guardrails that we would enforce with these AI platforms to make sure that those attitudes that are prevalent or that prevail in our legal fields right now don't carry over into this AI legal world that we're building, if we had human, even if the human factor was input into that, meaning that you have human people looking at the laws, at the ruling, that these platforms come up with and are the final vote. I'm not sure really that does anything, as Justice Ferrari had said, because you still have your bias. And the other thing I worry about is that using these systems right now, using the systems like the recidivism platforms, even knowing all the problematic portions of it, what it does, I mean, if you have that in mind, knowing that this is biased, there's still a certain aspect of bias confirmation, right? It's telling you what you already believe. So that just kind of calcifies whatever you already believe. And then that's can have really detrimental impacts to people who are vulnerable groups. So I think that's a question I still have. Would not the ethical thing be to put a pause in using the systems and sort of work on them outside of the legal field before we bring them in? But that's an argument that we can make for and against. In terms of data centricity, I think that is a really, really important factor in making sure that bias as much as it can be is mitigated, making sure that there's equitable distribution of these benefits. Because data centricity is this revolution that data is the most important asset of these applications, right? And if we make data the most important asset, then what we can also do, take it a step further and make sure that the methodology of creating these data sets is also sort of like a high priority factor. And I think the best way to do that would to really push this movement of localization, so localized data creation. So data is very global, and that's great, and access to that data is great as well. But I think there's something to be said in creating sets locally, because in theory, those data sets would reflect the environment and the people a lot better than data sets imported in or data sets accessed in other ways. So I think data creating localized data sets and using those specific localized data sets to train the algorithms may go a long way in making sure that they are unbiased as possible. And if it's unbiased, then the theory is that it's a more equitable use of those systems. So data localization, I think, is something that needs to be discussed a lot more in terms of data creation and data centricity. Another thing is data ownership, which is a discussion that comes up, but I think is a little bit fraught because we are we're really eager to champion globalization in all aspects, and that's not a bad thing. But I think the worry is if there is a power imbalance that exists in terms of experience, in terms of I guess, leverage, for a lack of a better way of saying it, in terms of a bigger stick, as it were, when you look at things even nationally. So regions in the global south versus regions in the US or the EU or the UK, an argument can be said that when we're looking at these things like trade agreements or international trade agreements, the leverage is not with us, right? So when we have these rules and we set the standards and their global standards, I think we really need to be careful when we are looking at them to make sure that their impact is beneficial to those with the smaller stick, as it were, with the less leverage. Just data ownership is something that I think we need to fight for, that we own our own data and then we can choose to do with it as we please. And that could be, sharing it, or it could be holding it close and, see how that pans out, which is really not the case right now. As I said, right now as a whole, again, general statement, but Africa, we tend to export data out, and we export it with very few strings attached, either because we can't attach those strings, or, maybe it's just not a conversation that has been had. So data ownership, I think, is something that we need to look into, in terms of also the use of AI in the legal systems. Once we input that data in there, what's happening if we're using imported platforms. So I think there is a lot of positives to using AI across the board and using AI in the judicial system. For example, in Kenya, we had a massive backlog of cases, but with the implementation of ICT technologies and some of those are AI-enabled tools, we've seen a significant reduction of this backlog. But I think we really need to be careful not to buy into the silver bullet narrative with AI, especially because that narrative, the genesis is not really with us specifically in the global south. So I think we need to be critical in our application of these tools and just really question why we're using them, how they can benefit us, and even maybe just ask whether we should be using them. I think that's something that people shy away from. The consensus seems to be jumping right into we should use them and they will XYZ and then interrogate that. But maybe we need to take a step back and just say, on a global level, if we're seeing we're seeing bias in tools like the recidivism platforms. Should we still employ them? And then maybe on a more specific level in Africa or in the global south as a whole, if these tools, if the narratives, if the technology itself, if all that is being imported to us, maybe we need to take a step back and really see whether this is beneficial for us to use, and then go from there once we have our answers. Thank you. I hope I didn't run too long. Thank you.
Thank you, Dr. Wairegi. And I'm using the last minutes we have to address some very interesting questions that we have on the chat. The first one is from Ms. Angeline. She asks, I would like to have your opinion on a case of AI ethics, promotion of a robot as a CEO of a company. And I don't know if the other panelists have something to say about that, but before getting to any discussion of like liability of a robot that works as a CEO of a company, what I would highlight is that the state of AI that we have nowadays, that is weak AI, does not allow us to deliver the activity of being a CEO of a company to a robot, because the state of AI that we have nowadays, weak AI, is different from strong AI. Strong AI is something that resembles a lot like human knowledge or human intelligence. If you have seen that movie, Her, from Spike Jonze, it's basically that. It's something that might interact in very different ways and take decisions in very different fields. So we don't have this kind of intelligence till nowadays, and we don't know when this might, when we might have something like that. So the state of AI that we have nowadays is an AI that is trained to do a specific activity, and that being trained to do that specific activity might act in a satisfactory way doing that. So for example, we could have a robot on a company that we could adopt to make hirings, or we could have a robot on a company to do the investments of the company, or we could have this robot to manage some specific thing, but not like being a CEO that you have to have like multiple abilities in very different fields. So it's not something that nowadays is realistic. Okay, I don't know if someone else would like to add something to this discussion. If not, I would go directly to the very interesting questions that Professor Ash have brought to the judges on the panel. He asked, what types of explanations for machine learning predictions would be most useful for judges? Would it be useful to know how accurate is an algorithm, or how confident it is in a particular case? Would it be useful to know what features, characteristics it usually uses for the prediction, or what characteristics are pivotal in a particular case? If an algorithm was adjusted to make it fair towards some groups, would it be important to know that and to know what adjustment was made in a particular case? And I would give the floor to the panelists, but before, I would just like to highlight something about Brazil. As I mentioned before, we have 64 projects of AI in the judiciary today in Brazil, and the National Council of Justice that is responsible for the implementation of these programs has made like a panel for everyone, not only judges, but for everyone. And in this panel, the National Council of Justice brings information that everyone can understand on, for example, what is the origin of the data? Is it like public data? Is it private data? Can the technical team explain how the inputs became the outputs? Can the non-technical team explain how the inputs became the outputs? And what is the region? What is the court? How long it was developed? What is the technique? What does it do? What is the objective? So this kind of informations help us to clarify some points, because as Siegfried mentioned here, to deal with opacity, there is a new field that has been developed and has gained traction in the last 2 years that is called explainable AI. So you use algorithms to explain how other algorithms are operating. But one of the problems of the explainable AI field and explainable AI is a field of basically computation, is that when you take one of the papers, where they bring the explanation of how that algorithm is working. Like, we people that are not from the programming, we don't understand anything. And that's not the information that we judges need. We need just to understand how is how has been the data, how has the data been selected? What were the main decisions? What is the objective? Has it been trained? Has it been tested? Is there any difference among ethnical groups, for example? So one of the tasks that we, the men of the law, the men and women of the law, and the society itself have, is to tell programmers what kind of information we need and how do we want to receive this information. And then that's exactly what Professor Ash asked, because if you take a look at the chat, someone here asked us, so judges, do you think the equalized odds is a good fairness criteria? And that's exactly the problem. We can talk in this line of programming words. We don't have this vocabulary. So how should we bring this to our reality? I would love to hear what the other panelists have to say on that. I don't know if someone wants to take the floor to say something.
I'll jump in. Fools rush in where angels fear to tread. I will. I don't think. First of all, I think all of the questions that Professor Ash poses as would it be helpful for judges to know, the answer to all of those is yes. I think that Judge Ferrari has done a superb job of capturing the list of things that we don't know that we need to know before we can use artificial intelligence in a way that we don't want to approach artificial intelligence with genuine stupidity. So we need to be smart in terms about what we are seeking to use artificial intelligence for. And I think that you have done a superb job of sort of capturing that from a broad perspective as well as a narrow one. But the key is that all technology is designed to do something. There are parameters under which it does it. It has been tested using certain data, and there is no such thing as a perfect outcome. And so the types of questions that Dr. Ash says, would knowing this software was developed for this purpose. It was done under these parameters. It was done, tested on this population, but not as for that. It was designed for this particular function, but not for this another function. That would all be helpful to be able to be used at it. But I think that the point that Judge Ferrari made that is so critical here is, and I thought I saw on the scroll someplace, someone said that strong AI was a fallacy. I think that in today's environment, I think most people think that there are a large number of data scientists that believe that strong AI will never exist because the mechanisms by which human decision making takes place are so complicated. We still don't even know how the human brain works. We're still learning more about that and neuro functioning these days. So what we have is we have weak AI. It may be stronger AI because it has multiple different levels of being able to be used. But the day that we can substitute human involvement, particularly where the outcome is very, very critical, is maybe best reserved for science fiction at the present time. I think that coming up with some standards that would help in terms of just how transparent AI must be. I like the idea of explainable AI, but there are some things that you can't explain, but they are accurate. And that gets into some of these biases that we've talked about. Automation bias says, well, it must be right. A computer did it, to AI aversion, which is, oh my gosh, we can't have anything to do with this because a human was not involved. We're just getting started in this. The questions that have been asked and the observations that have been made during this program are really superb because it shows that we're now beginning to understand in a much better way what we don't know And that will help us to develop the proper courses to get that which we need to know for the roles that we're going to allow this to play in the judicial system.
So, of course, as we can see, we could stay here for the next 2 or 3 days and we wouldn't end this discussion. But unfortunately, we're running out of time. So I'd like once more to thank all the panelists. I'd like to thank all the attendees. And I'd like to say that it has been a pleasure to be here, to hear all of you. And I would like to give the floor to our dear Prateek again, to the last remarks, to the closing words.
Thank you, Judge Ferrari, for excellent moderation, and to our fellow panelists for a really insightful conversation. And the good part was we took 2 hours to really dive into the questions. A lot of times we tend to just stay on the surface on problems of bias, discrimination. And I know all of you have court to attend at different points, but I saw that Judge Khaled unmuted himself. I don't know if you have 30 seconds of last thoughts, or we can conclude.
Thank you, Prateek. Actually, I was prepared to answer another question on the implications of artificial intelligence in relation to the judicial work. But I see that we're all running out of time, and I have to open another meeting actually in a few seconds. So I think I'll take a rain check for that, and maybe in the next event I will have the enough time needed to address this point. Thank you.
For sure. Thank you so much to all of you. We'll conclude this session. We have a course on AI and the rule of law from UNESCO, which is free and available in 7 languages online. So I'll just invite the technical team to play this video. And with that, I thank all the speakers and the panelists and Judge Ferrari for joining us. And we hope to work with you and continue this dialogue globally. Thank you.
Thanks, everybody.
As AI systems are deployed across the world, their use is raising important questions related to protection and promotion of human rights and fundamental freedoms. How are judicial operators affected in their quest to uphold the rule of law in the age of AI?
What are the implications for human rights?
How can AI be adopted to improve the administration of justice?
UNESCO's Judges Initiative is at the forefront of engaging judicial systems on the protection of human rights, both online and offline. This MOOC on AI and the rule of law is a 6-module introductory course developed by UNESCO and the Future Society, bringing together a lineup of diverse subject matter experts from around the globe.
We will discuss the digitalization of justice systems and the rise of online courts.
We will also explore the implications of the use of AI on human rights with respect to questions of bias, discrimination, privacy, and freedom of expression.
Throughout the course, we will touch on examples of AI use across different justice systems and the emerging jurisprudence in the domain. We aim to have a participative dialogue and promote knowledge exchange to help you build capacities to effectively address AI issues across justice systems.
Join the debate
and enjoy our lectures.